Hello viewers, welcome to today's session of Nigerian Law Documentary. Nigerian Law Documentary is a legal education platform where legal topics, emerging legal topics that affect Nigerians in their everyday life, such as landlord and tenant, criminal law, civil law, and other areas of law. We discuss them in such a way that even a person that has not been to primary one in his life will understand and will actually relate it to his everyday life. So I encourage our viewers to subscribe to our YouTube channel, which is Nigerian Law Documentary, and as well follow our Facebook page. Comment. Let us hear your own point of view, and you can actually comment on some certain topics that you find very interesting but very difficult to understand. Nigerian Law Documentary will give an authoritative discourse on such topics. So I encourage our viewers to share our videos to persons that you think our videos may help and refer persons to our YouTube channel as well our Facebook page. So on today's session, it's like a continuation of our previous session on validity of ill-motivated notice to quit. We made reference that in our next video, we'll be looking at ways a tenant can challenge a notice to quit. And this will be the focus of this video. And in looking at the challenge of a notice to quit, we'll be looking at the essential ingredient because it is on this basis that a tenant can challenge a notice to quit simpliciter. So there are about 5 ingredients of a valid notice to quit, one of which is that the notice to quit must be issued by the landlord himself. Notice to quit by the wife of the landlord, child of the landlord is not valid unless there is a power of attorney donated to such a person. The second ingredient is that a notice to quit must be addressed to the tenant. And though this may be very simple in theory, however, in practice, controversy may arise as to who is the tenant. A person a man that rented an apartment for his mistress who stays in the apartment, there may be dispute as to who is the tenant in such cases. When drafting a notice to quit, is the landlord going to address the person in possession as his tenant or the person that actually rented the apartment? So in such cases, if the landlord should address the notice to quit to the mistress in possession, he may be wrong because it is not the mistress name that is contained in the tenancy agreement as the tenant. It is the man that rented the apartment. So this may be an issue of controversy too. Also, there may be dispute as to who is the tenant in situation where a man rented an apartment for business purpose. He rents the apartment in his name and he carry on business in the apartment. Let's say his name is Chima, while the business name he's using is Chima Enterprise. So the landlord who address the tenant as Chima Enterprise may be wrong, and a landlord who address the tenant as Chima may also be wrong, depending on the name contained in the contractual document, whether it's Chima Enterprise or Chima. So this may also be an issue of dispute. The third requirement is that the notice to quit must describe the tenant as a tenant, and as well it must also give a vivid description of the property is occupying. Is it a bungalow? Is it a one-room apartment? Is it a shop? So is it a flat? So the tenancy agreement and the notice to quit rather must also give a vivid description of the property is occupying. And this may also be an issue of controversy where the property given was a virgin piece of land and the tenant developed it into a business enterprise. So this may cause a problem because the tenancy agreement contains a bare piece of land while the subsequent development on the land changed the nature of the property. So this may also be an issue. The fourth requirement is that the notice to quit must describe the nature of the tenancy, whether it's a yearly tenant, half yearly, monthly, weekly, or even daily. There may also be a controversy as to the nature of the tenancy, most especially in a situation where the tenancy agreement clearly states that the tenancy is yearly. and the mode of payment by the tenant, he pays monthly. So which one is the landlord going to adopt in issuing notice to quit? Is it the actual payment of rent or the one contained in the tenancy agreement? So this may also be an issue of controversy. The fifth requirement is that a valid notice to quit must contain the date for which the tenant is to give up possession. There shouldn't be any ambiguity as to when the tenant should give up. That's the most important, in my opinion. So what happens in a situation where all or any of these ingredients is not present? Does the notice to quit becomes invalid? With regards to this, there are at least two schools of thought that proffered their opinion and gave convincing reason for such opinion. The first is the contra pro farentem school of thought, and the second is the Manai investment school of thought, which was developed by the English House of Laws in the case of Manai investment and Ingu Stars Insurance. The case decided in 1997. Going to the first school of thought, which is the contra pro farentem school of thought. They based their argument on the view that notice to quit are unilateral document. Therefore, it should be construed against the drafter of such a document. Notice to quit should be construed strictly against the landlord or any person who drafts such a notice to quit. Therefore, any ambiguity, any irregularity, any errors in the notice to quit should be construed against the drafter of such a notice to quit. Therefore, if any of these ingredients are absent, it should be construed strictly against the person who drafts such document. The reason why I am saying the person who drafts such document, not actually the landlord, because notice to quit can either be issued by the landlord or the tenant. It is on the basis of mutuality. The law permits both landlord and tenant to issue notice to quit. Coming to the second school of thought, which is the Manai investment school of thought. This school of thought was developed in the notorious case of Manai Investment versus Eagle Star Assurance Limited. The tenant was the one that issued notice to quit in this case, and the notice to quit was to take effect on the eve of the anniversary of the tenancy, and the eve of the anniversary of the tenancy ought to be 13th January. However, in the notice to quit, the tenant made mistake and he inserted 12th January. Therefore, the landlord challenged the notice to quit. However, it is the authoritative opinion of the House of Lords in this case that documents should be construed in context in which they are made. That it is not enough to assert that there was an error. The most important thing is that whether such error has misled the person whom it has been addressed to, or is capable of misleading any reasonable person in the shoe. So the test for ascertaining whether a notice to quit is valid or invalid according to this school of thought should be objective. Is it capable of misleading? Basically, these are the two schools of thought with regards to the essential ingredients of notice to quit, either the contra pro farentem school of thought or the Manai investment school of thought. So whether the court adopt any of this school of thought is a question of fact that may be determined by the fact of the case that is before the court, whether the said error is capable of misleading the addressee or not. However, in Nigeria, there is at least one law that is in supportive of one of these school of thought. This law is the Interpretation Act. Particularly Section 22 of the Interpretation Act is in support of the Manai investment school of thought. The said law clearly made provision that when there is a mistake as to a particular form, the test as to whether that mistake is capable of defeating that form or not, whether the said mistake is capable of misleading. If it's not, then the mistake is immaterial. Therefore, whether a notice to quit is invalid or not because of this essential ingredient is a question of the school of thought that the court should adopt. And just like I said, in Nigeria, the court may likely go with the Mana Investment School of Thought because it's the most recent, and as well because there is a statute in Nigeria, Section 23 of the Interpretation Act, that is in support of this school of thought. So I encourage our viewers to follow our Facebook page, which is Nigerian Law Documentary at Facebook, and as well subscribe to our YouTube channel because you have nothing to lose. However, you have a lot to gain in following our channel. Anticipate more interesting law videos. Thank you.